So the first case that we're going to do in this area is Bradwell v. State, which takes place in 1873. You might ask yourself, why does it take so long? um, Gender-based distinctions in law seem absolutely repugnant. Why does it take from the founding of the nation to 1873 for there to be a Supreme Court case that deals with gender-based distinctions? And there's a myriad of answers that I could give you, but the best way I can explain why it takes so long is because when every systematic structure and institution is set up to make sure that this distinction remains, it is very difficult to challenge it. And so it should be as no shock about where the first important challenge to gender-based distinctions come from, and that's from within the legal academy itself. So Maya Bradwell, who is the party in this case, was a married woman with a law degree. It's not clear from the record how the law degree was obtained. And the reason for this, as an aside, is because there wasn't a lot of formal legal training that went on during this time. Most individuals who became attorneys didn't attend law school. Law school wasn't a thing that most people did. What most people did is they learned the legal trade through apprenticeship. And it seems somewhat clear by the historical record that part of Bradwell's training was in that vein. But in any event, Bradwell did have a law degree. She was educated as a lawyer. But in order to practice law, as most of you know, as you are thinking about going on to go to law school, you have to be licensed to practice law. It's not enough to have a law degree. You have to be licensed. Bradwell resided in Illinois, and the only way by which you could get approval for a license at this time to practice law in the state of Illinois was through the approval of a panel of judges of the Illinois Supreme Court. The panel, not shockingly, turned down her request solely because she was a woman. Nothing else was considered. It was the only factor, it was the only reason for their vote. Maya Bradwell is a woman, and therefore she cannot have a license to practice law in the state of Illinois. When the case reaches the Supreme Court, it's an 8-1 decision. And the U.S. Supreme Court agrees with the panel of Illinois, stating that the rejection of her license does not violate the Privilege and Immunities Clause of the 14th Amendment. So why are we using the Privileges and Immunity Clause, which is a very underused clause in most legal circles? And the reason is that Maya Bradwell claimed that as a former resident of Vermont, a state in which she did have a law license, the state of Vermont had given her a license to practice the law. She argued that she was entitled by the Privilege and Immunities Clause of the 14th Amendment to a law license to practice in the state of Illinois. The Supreme Court denies that such a privilege and immunities claim can actually exist. The opinion argues that the protection was designed by that clause has no application to a citizen of the state whose laws are complained of. If the plaintiff was a citizen of the state of Illinois, that provision of the Constitution gave no protection against the courts or its legislation. Now, it should be no shock that the court cites as binding in this case the slaughterhouse cases. The slaughterhouse cases were decided just a few months earlier, and the slaughterhouse cases really limited the scope of the 14th Amendment by making its application to only African Americans and former slaves. So it's not shocking that it killed any prospect for using a broader definition of the Privilege and Immunities Clause. The author of the slaughterhouse cases, Justice Miller, is also the author in this case, further sort of driving home the idea that we shouldn't really be shocked, because this is a court that very much limits the application of the 14th Amendment in many ways. And this is another example of how it limits the 14th Amendment. I said that the vote was 8-1. So clearly there was a justice on the court who disagreed with the majority. That individual was Chief Justice Chase. But in a shocking sort of turn of events, he casts a no vote, he casts a dissent, but he doesn't write an opinion, which even in the 1870s is a rare event. Usually if you dissent with, almost always, if you dissent with the court, you write an opinion stating why you disagree with the majority opinion's reasoning. Chief Justice Chase writes no dissent. So we don't know, and the historical record provides us no reason why Chief Justice Chase dissents in this particular case. The majority opinion in this case is overshadowed, frankly, by a concurrence. The concurrence is written by Justice Bradley. Justice Bradley's concurrence goes to show just how deeply ingrained gender-based stereotypes were within the United States and how deeply wrought they were within the law itself. He states of Bradwell's claim that it is based upon the supposed right of every person, man or woman, to engage in any lawful employment for a livelihood. So he makes that she's claiming that everyone has this right. She claims that her right to her livelihood is fundamental. Yet from a historical perspective, that has never been the case. I'm going to read a long quote from Justice Bradley because I want you to hear it said out loud. Reading it isn't enough. Justice Bradwell writes, "On the contrary, the civil law, as well as nature herself, has always recognized a wide difference in the respective spheres and destinies of men and women. Man is, or should be, woman's protector and defender. The natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life. The constitution of the family organization, which is founded in the divine ordinance as well as the nature of things, indicated the domestic sphere as that of which properly belongs to the domain and functions of womanhood. The harmony, not to say identity, of interests and views which belong or should belong to the family institution is repugnant to the idea of a woman adopting a distinct and independent career from that of her husband. So firmly fixed was this sentiment in the founders of the common law that it became a maxim of the system of jurisprudence that a woman had no legal existence separate from her husband, who was regarded as her head and representative in the social state." In his concurrence, Justice Bradwell very clearly defines what the law thinks of women. And that is, the law doesn't think much of them, if at all. They don't exist under the law. And if they do, they exist because their husband has transferred his rights to them. Furthermore, Justice Bradwell, of course, is not done. It is true that many women are unmarried and not affected by any of the duties, complications, and incapacities arising of the married state, and these are exceptions to the general rule. The paramount destiny and mission of women are to fulfill the noble and benign offices of wife and mother, because this is the law of the Creator. This is a brief part of Justice Bradley's dissent, or of Justice Bradley's concurrence. It is echoed by other concurrences that were written. So in an 8-1 opinion, we've clearly carved out what the rights are for a woman in the United States in the 1870s. There weren't any. And so despite her challenge, and despite her legal training, and despite the fact that her husband approved of all of it, it didn't matter to the court. And what it meant is that laws that prohibited women from exercising any form of political capacity, any form of employment independence, and any form of actual independence and freedom were repugnant to change from the Supreme Court of the United States.